You're listening to God, Law, and Liberty with David Fowler and Gary Humble. We're putting culture on a collision course with the truth.
Welcome to God, Law, and Liberty. I'm Gary.
And I'm David.
And we've got more of a sort of a spiritual, philosophical discussion today.
I think it'll be a fascinating, also historical analysis of how we've gotten to where we are on some of these things that we're facing with abortion and same-sex marriage and free the nipple and all those things we've been talking about. I think it'll give people some history of, well, that's why we're so messed up. It's like, yeah, that's why we're so messed up.
That's good, because I know I ask myself that question all the time. Good Lord, how did we get here? Yeah. And,
I was just down at the Capitol, what day was it? Wednesday of this week, talking to Representative Bill Dunn, who's going to be retiring at the end of this session. And Bill is the most senior member of the House, and we actually came in together. And I came into the Senate, he came into the House. And so I would now be there 26 years, I guess.
Had you stayed.
Had I stayed. Wow. And I was telling him, I was sitting in another legislator's office waiting for my turn to talk to the legislature, and he had 4 or 5 transgendered women, men who had moved to women, who were talking to this legislator about the bill on high school sports.
Okay.
That, if you transgender, you can compete in the event, you just can't win.
Yeah.
You don't get the ribbon, you don't get the prize, you don't get the state championship, you don't get the record, but, you want to run, go ahead and run. And so after I was sitting there for that meeting and I had to leave, that one went long, so I went to see Bill Dunn and told him what I'd been sitting there listening to. And I said, when we came up here, the big evils were lottery, abortion, and TennCare. I said, who would have thought when we started 26 years ago, we'd be talking about men in high school, boys in high school wanting to compete as women.
Wow.
Against women, and so anyway, yeah, you kind of wonder how did we get here? Well, today we're going to talk a little bit about that.
Yeah, and who would have thought these men that we're kind of quting, from the late 1800s would have thought that we'd be facing the things we're facing today.
That's right.
In 2020. Yeah. Well, I read, I have these 2 volumes on my desk of de Tocqueville's pondering on the American Republic.
Right.
Right. And he rewrote the volume I have I believe it's the 15th edition, and in that, he originally wrote this, I think, in 1835, and then he updated his introduction, and this was written in 1848. And I thought this would be a good kind of start, of a foundation for, and
so this is 1848.
1848, and de Tocqueville in this intro, he's really speaking to the French. He's speaking to his people, and he's saying, we ought not to be scared of what's happening in America. It's really working. This democratic republic that they've set up, this rule of law, it works. Yeah. And he closed his intro by saying this: but the principles on which the constitutions of the American states rest, the principles of order, balance of powers, true liberty, and sincere and deep respect for law, are indispensable for all republics. They should be common to them all, and it is safe to forecast that where they are not found, the republic will soon have ceased to exist. And the one I underline that I thought was important for today's discussion is one of these ingredients for a successful republic is a sincere and deep respect for law.
Right.
And it's this idea that, and I don't know that.
And what he said there that was fascinating to me is, it doesn't take much to prophesy. What did he say at the end? That they won't soon exist?
Yeah, without these things, the republic will have ceased to exist.
Yeah. Wow. Okay. So in other words, he would be saying to us today, if you've lost these things, you're not long to exist.
You can kiss your republic goodbye.
That's right.
It's heading out the door.
And one of them is respect for law.
Right. Which obviously.
Now, in a show called God, Law, and Liberty, why would that catch your eye?
Yeah. No, exactly. Well, and I also won't get into this, but he didn't say liberty. It's interesting. He says true liberty.
Yeah, true liberty.
I'm curious what he means by that. But
yeah, well,
we'll discover that exactly. Another episode.
Another episode. But the question about law today.
But this deep respect for law, and the idea that if one was to have respect for the law, that would say that We trust it. We believe that it has a some sort of transcendence. Maybe it's something that roots our society.
It ought to be what it is, or it's good that it's the way it is.
Right.
And you think we're losing that?
Well, I just, and we'll get into some of these quotes. But, since the late 1800s and early 1900s, and you've talked about this a lot, how law schools, in fact, me being an uneducated person interested in the law, not educated in the law itself, sometimes have a little bit more sense about the law than maybe a lawyer who's been practicing for 30 years, not because I'm smarter, simply because when, like you said, when you learn the law in a law school, you learn it from a certain perspective.
That's right.
And you get ingrained in a certain way of administering law. Right. And it's hard to break out of that.
No,
it's hard to see the forest through the trees.
Well, it's almost like anything. If you're raised in certain kinds of families, you're going to think this is the way families operate, right? So you're right. People like you just kind of have a common sense that doesn't smell right, that doesn't look right. It's waddling like a duck and sounding like a duck. I may be a duck, David.
I'm not so sure it's a cat.
Yeah, and I'm like, no, it's a cat. It's a cat. The judge said it was a cat. So anyway, so that's a great point. And having been trained in law, everything people will hear me say on this podcast, I learned long after I left law school. And so, one, that should tell everybody that, oh, well, David's got some special education. I can't know all that. No, David got a bad education, and he's learned everything he's learned since then. So you can learn it too if you want to. Depends on how much you want to know. And we hope this podcast can save you the 30 years that I wandered in the wilderness between age 24 and 54, not understanding basic true legal concepts. And so we can hopefully on this podcast save you 30 years of wandering in the wilderness, or 40, I think, is the typical age for wandering in the wilderness, so that you can learn some things that I didn't learn, that I've had to learn separately, and what happened in legal education that I didn't even realize had happened. It would be as if you woke up someday and nobody had antibiotics and everybody was doing homeopathic medicines, and you're like, you mean we used to have antibiotics? Or vice versa. You grew up homeopathics, and it's kind of like, well, or you grew up on antibiotics and you say people used to have homeopathic kind of remedies. It's like, oh yeah, they'd get a bark of this and a twig of that and a berry from that, and your cold would be better in 3 days.
Yeah, it worked.
Yeah, it worked. So I didn't learn that there was something else to learn. We didn't talk about it, and because that was passé, it was old. And so today we're going to talk about some of that, and it has bearing on where we are as a country, and what I think we need to get back to, but how we can also, if we can get it all done in the next 25 minutes, how we can also use that to our advantage.
Yeah. Well, let's talk about where it broke. So, we said before we started, our framers started
right
from the perspective of the common law.
That's right.
Of William Blackstone.
Right.
This idea that there was a transcendent law, that there was a natural law, mandated by God,
right,
and that we had inalienable rights endowed to us by our. So there was something, and we've talked a lot about the Ninth Amendment.
Sure.
These laws that were pre-government, pre-Constitution, or even, should we say, are superior to, transcend the Constitution. That the Constitution, no law of man should infringe upon.
That's right.
Right.
And what they were saying by the Ninth Amendment, we retained any that we didn't list.
Right.
And we expect our representatives to protect and secure them.
Yeah.
We can't spell them all out. But when you see somebody infringing on one, that's when we retain the right, and I go to my legislator and say, hey, they're killing the unborn in my nation.
Mm-hmm.
They're not allowing me to marry as a man and a woman, just as two people who love each other. And I want to marry as a man and a woman. I have that right, protect that right. So that's what that Ninth Amendment was talking about, so that you're right. They did believe there was law prior to government. The common law was the notion that over time, history and tradition and experience had made clear that certain things are true, that our memory of them, we can't even remember when we didn't really know them anymore, that they weren't true. And what was fundamentally important, because the Supreme Court will still give history to lip service to history and tradition. That's been part of the dissents in the abortion cases. If we don't have a history and tradition of ordered liberty, that was the other word he used, order, where abortion was fundamental to your being able to be a free human being. Why is abortion at the root of being a free human being? Or why is getting to marry between two people of the same sex at the very order, at the fundamental historical foundation of ordered liberty? They would have said, but we don't know any of that. It doesn't exist. But the point was, we've had these things for so long, but it's not just history and tradition, they would have said, which is all the Supreme Court would say.
So we would say today.
So that's all they'd say today.
Right.
In the past, they would have said, well, no, there is a natural law that exists. It's woven into the nature of things. And then they would have gone further, particularly in England and in the common law countries, Scotland and all of those. They would have gone further and said, but they are made more clear to us by revelation. So we can test our experience and say, wait, this isn't right. This seems to be contradictory to the revealed truth that we have, because we don't trust our unaided reason to just come to things, because we're fallen human beings. Our reasons, as Blackstone said, is imperfect and ruffled.
Yeah, well,
so
one of the statements here, it says, human reason corrupted by sin is an inadequate mechanism for understanding and implementing divine law.
That's right. So that's what Blackstone would have said. And so he would have said there is this divine law, this natural law, and the goal of civil government is to conform the laws of men as closely as possible in the particular applications in order to do what's just and right, because God always would do what's just and right, and God's given us principles that must be just and right because God's given them to us. So that was the whole idea. That's what Adam McLeod testified to back during the heartbeat bill testimony in the Senate back last August, that the goal of the civil government was to affirm and make more secure our common law rights. And so when one gets threatened, we would pass a law to make sure everybody knows, no, you really do have this right. See, that's how marriage started. Everybody knew you had a right to marry. Men and women have been married forever. Well, how do we make that more secure? How do we know that Bobby and Susie aren't just shacking up? Well, let's pass a registration law, and and eventually over time, we got to the point we thought we created marriage. Well, no, we never thought we created marriage. Men and women have been doing it forever. We just were trying to make more secure the right so that later Bobby couldn't lose Susie and say, well, we were never married. They were protecting marriage, not creating it. So anyway, there was that important fundamental concept that there was pre-governmental law. And that law was essentially transcended man. And so it was said that the judge did not make law. Now, we've used that phrase a lot. Courts don't make laws. Courts don't make laws. And there's two senses in which that's true and a sense in which it's sort of not true. And we've confused the two. The lights that guided us went dim. So I'm sitting here looking right now at Blackstone's commentaries, and he's addressing this question, which we're going to get to about common law. And it says, so how do we know what the common law is? It says, well, the judges are the depositories of the law. They're the living oracles who must decide when we have cases of doubt as to what we should do in a particular situation. And he said they're bound by oath to decide according to the law of the land. Okay, so the judges are sitting here informed by reason and revelation. They have certain basic principles that they adhere to. And then they deduce from those principles how to apply them in this situation and why this situation is a little distinct from this one. So I'd apply a little different rule in this case from that case, but the fundamental principle is still there. Okay, so for example, marriage is a thing that exists. It's real. God gave it to us. Well, all of a sudden, Bob leaves Susie, and the court says, well, we should secure and protect marriage and you made a promise that you would care for somebody, so we're going to uphold promises. God is a God of truth. He keeps his covenant. He keeps his covenant word. So you have to help provide alimony for your wife. Because, see, I started with the basic principle, and I deduced that that's what you should do. Then the next case comes along, and Sam has divorced Sally, but he's left her with 3 children. Well, now what do I do? Because I have a little different situation. I have children now in this relationship. So I begin to again deduce. We have a thing called marriage. It should be held secure, sacred, blah, blah, blah. It should be protected. And since we provide support for the wife after the promise was made, we should extend that principle to you should provide for the children that were produced as a result of the marriage. So the law would develop and it would grow, but it grew from a principle that was taken as true. You didn't just stick some arbitrary principle out here and say, okay, we decided marriage is a good thing, so now let's protect it. No, marriage was given to us by God. We should protect it. So
it grew from something fundamental that won't change.
That won't change, that didn't come from us.
Yeah.
That we could make it different if we wanted to. So what Blackstone says in this, and this is good, is they said that so that the law and the opinion of the judge are not always convertible terms or one and the same thing, since it may sometimes happen that the judge may mistake the law. Upon the whole, however, we may take it as a general rule that the decisions of the courts of justice are evidence of what the common law is. In other words, the law of God doesn't change. It is what it is. We may apply it mistakenly, but our application of it isn't the law. It's our understanding of the law as it applied to that situation. The law is above us. It transcends us. It's outside of us, so that when we come back later and we say, wait a minute, we were mistaken here. This wasn't really a marriage. These people were just shacking up. There was no duty assumed. We've been treating it just like a marriage. We were mistaken. Marriage is not just shacking up. It's a different thing. Shacking up is a different thing. So we have to apply a different kind of rule to that. So the decisions of the courts were not considered law. Now, they were the laws between the parties, so that when I said you had to pay money, for alimony, you had to pay. And in that sense, they were law. But courts didn't make laws, okay? Now, that's what the common law was. Civil law was when the legislative body or the parliament or here Congress or the legislature enacts a law and says, okay, this is what a real estate contract needs to look like. I mean, we've had contracts forever. They're part of the common law. But for some reason, because real estate is, let's say, very important, lots of fraud takes place, the legislature says we're going to make it more secure, the contracting of real estate transactions. So here's how you have to do it. Not to create the idea of we can have contracts, but to make them more secure, make it clear. And that's called civil law. So sometimes when you read court opinions, you'll see them talking about common law and civil law. And they're talking about two different concepts of the nature and source of law. Common law is rooted in history and tradition, consistent with natural law, confirmed by revelation. Civil law is made by the legislative body. They can conform to the common law, secure the common law, or they can breach or abdicate their duties. Either way they go, okay? So anyway, that's the situation. So here's what began to happen at Harvard, which was the leading law school, founded by strong Puritan theologian type people. They departed from Blackstone and brought in a head of the law school, Henry Langdell, and I think you have something on him there, and I don't know if you have something you could read, but Langdell departed from that understanding.
He began to operate completely opposite to what you were just saying.
That's right.
He approached cases differently. He believed, whereas Blackstone would appreciate that law over time, evolves case
and
after
that
case.
Court opinions are helping clarify how you apply it, right?
He would still have an understanding that those laws were still rooted in something fundamental
That was fixed.
that
That's right.
would not change.
That's right.
Langdell was different in the sense that he just took God out of the equation and assumed that the cases themselves and the decisions themselves were the quote unquote original sources of legal doctrine.
Right.
So in Langdell's mind, when a judge made a ruling, that was the origination of the law. Nothing, forget everything that came before it.
That's now the law.
This is the thing.
Right. And see, we just said, Blackstone would have said, oh, no. You could have mistaken the law.
Right.
Your decision is just evidence of the law.
And Langdell's determination is like, no, I just made the law.
That is the law. I made the law.
Yeah.
See, so now we can see when people say to me, well, the Supreme Court said that's the law. I want to say, I know what world you're living in now.
Mm-hmm.
You don't understand. When I say courts don't make law, for some people, that's just mind-boggling.
Yeah.
Well, of course they make law. Blackstone would have said, that's mind-boggling, you think they do. You see how we flipped the script? I mean, Christians who don't understand that we don't live in the world they thought we lived in, and they don't know why we don't get it anymore. It's because we took law. If you could watch me, and we took the foundation out and turned everything upside down, and that's why we now say courts make laws.
Yeah.
They don't. They exercise judgment. So when you read the Federalist Papers, written in the 1700s, see, we still understood this concept that courts don't make laws. They exercise judgment to resolve disputes between parties. They articulate what they think the law is, but the law transcends them. It exists outside them, and their opinion is evidence of the law. And that's why they said courts are the least dangerous branch. They have neither force nor will. They have no executive or legislative powers, but just judgment. They resolve a particular dispute, and as soon as the dispute is dissolved and the judgment is final, it evaporates in a sense. Now, there's precedent, and that concept's good, but the point would be, and this is what Clarence Thomas harps on now with his dissents. He says, look, if we got it wrong, we shouldn't sit here and say, well, we got it wrong a year ago. We better stick with it for a while because people will lose faith in the law. Or, oh, well, this has been the law for 100 years. We ought not to reverse it. He says, if the law's wrong, reverse it.
Right.
Now, I'm using the word law, notice. But he would be saying, really, no, it's not that the law was wrong. Our understanding of what the law is was wrong. And so we just need to
reverse.
reverse.
This new law contradicts what we've always known it to be, according to the root.
Yeah. He would say, these past evidences of what we thought the law, Blackstone, that's how he would have worked. Blackstone would have said, these evidences of the law since Roe versus Wade, turns out they're wrong. That's not the law. They are mistaken understandings of the law. We should reverse them and get back to the fact that life is given to us by God and is an absolute right that no person can take arbitrarily without due process of law. Well, what a novel concept. Oh, I think they wrote it in the U.S. Constitution, and the Supreme Court ignored it. Now, why did they ignore it? Because over time, they began to think, we make the law.
Yeah, if you went to, according to this history here I'm looking at, if you went to law school after 1914, which I think you did.
Yes, not that old. Yes, thank you, Gary.
at Harvard, Yale, or just about any other law school, you are, in some way, shape, or form, has been ingrained in your mind, in your way of thinking that you make law.
Yeah.
Whenever you argue a case, that you are having an effect in actually creating law.
Yeah, I had a good friend who was a Christian. He was a judge, and he was a judge of great integrity. But he said he wanted to become a judge at one point so he could help make the law and shape things. And I thought, wow, that's not your job. Your job is to resolve a dispute between particular parties. So here's what began to happen in the United States Supreme Court. So here's a little history lesson on this tussle, because what we're dealing with today is not anything new, except that the roles have reversed. So in 1842, Justice William Story, who I may have talked about here before, he wrote the first commentaries on the Constitution, youngest man ever nominated to the Supreme Court, brilliant man. Dane professor of law at Harvard. There were cases that would come to the federal courts, typically diversity suits, where it's a citizen from Kentucky has made a contract with a citizen from Tennessee. And something goes wrong in the contractual carrying out of the contract, and they sue each other. And it's enough money, and they go to federal court. And so the question was there a contract form? Or did somebody think this was really a gift? And so there was just never a meeting of the minds? Or was there an act of God that prevented the enforcement of the contract? Or was it just simply negligence by a party who didn't perform, or whatever it might be? And so we didn't have statutes governing everything. So you went to common law concepts about contracts, and we still apply them in courts today. Still do it, okay? So if the lawsuit had been filed just in Kentucky, they would have looked at what the courts in Kentucky had said about the understanding and the nature of contracts, and what we've realized is necessary for a contract to exist, and what's the difference between a contract and a gift, and what's the difference between a breach and an act of God. And all those things, we're starting with certain concepts, and we're applying them, as I just applied. Or if you were in Tennessee, you'd look at what the Tennessee judges did, but they were in federal court. And so the federal court says, well, what do? Do I apply what Kentucky thinks the common law of contracts is, or what the Tennessee thinks the common law of contracts is? Or do we say, look, there is a common law, transcendent law of contracts, and it's not limited to state boundaries. Everybody is trying to search out this same transcendent law and figure out how to apply it. So Congress had passed a law at the time, and here's the history of it, that said when federal courts are hearing these cases, that they should apply the laws of the states. Okay? Justice Story said, well, the word law has to refer to statutory laws because courts don't make laws. The law is something that transcends the court, that we try to figure out, we try to understand what it is and how it applies, but we don't make laws in any real sense of the word. So Congress must have meant enacted laws. So when you have this dispute over a common law between Kentucky and Tennessee residents, and the question is, what are the general principles of contract that we should apply? The court said, I don't really have to bind myself to the state of Kentucky's understanding or to Tennessee's, because I'm as free to determine what the transcendent principles are as anybody. And they may be mistaken, so I'm going to try to get it right too. So they would look at the laws of the Tennessee and Kentucky, but they might come to their own conclusion that maybe both states had gotten it wrong. Well, that went on until 1938, and then it stopped. And it stopped because of a guy named Oliver Wendell Holmes, who's quite famous. Oliver Wendell Holmes was an avowed atheist. He was an evolutionist. He had taught at Harvard. And he said, the problem with the old understanding in Swift v. Tyson is that there is no such transcendent law. And you may have a quote there, or I have one that we can read.
You have it.
I think I have it. But he says the fallacy underlying the rule in Swift v. Tyson, that's the 1842 case, is made clear by Justice Holmes. Now, he had died by that point. This is 1938. He died in 1935. The doctrine rests on the assumption that there is a, quote, transcendental body of law outside a particular state, but obligatory within it unless and until it's changed by statute. So in other words, there's this transcendent law and it applies all over the whole country. And it applies to state courts, federal courts, because it transcends the government itself. And so it's obligatory in every state. That, in other words, it's kind of like, well, God's law applies in every state but Oklahoma. No. God's law applies everywhere.
Right.
Okay? And he says it rests on this assumption. And that the federal courts have the power to use their judgment to figure out what it is, just like everybody else. And then he quotes Oliver Wendell Holmes, but law in the sense in which courts speak of it today does not exist without some definite authority behind it. God doesn't exist for Oliver Wendell.
Not this fake God authority.
That's right. Yeah. And Revelation can't exist if there's no God to reveal it. There is no authority behind this thing, Mr. Story. You're living in a fabled world. We now have evolution. We don't have God. We don't need God to explain anything anymore. The common law, so far as it's enforced in a state, whether it's called common law or not, is not the common law generally, like transcending all the states and state and federal courts, but it's just the law of the state, existing by authority of the state. It doesn't exist by the authority of God or by the authority of revelation or any authority outside of us. The only authority, he says this, and listen to this, the authority and only authority is the state.
Wow.
So you have taken the concept of God and transcendent authority, and you've done exactly what they did with Pharaoh and the Caesars. They reduced God to the ruler, to the man, here to the court. We are as pagan today, every bit as they were in Rome, as they were in Egypt. We've just changed Pharaoh and Caesar to a majority of 5 people in the United States Supreme Court.
Yeah.
Because, why? Because they get to tell us you can't have that kind of marriage anymore. Oh, you can't have abortion laws anymore. Now, here's the beautiful part of this, and we probably are getting to the end of our show. But we are working on this issue called the Marital Contract at Common Law Recording Act. Our idea is very simple. Marriage was not created by the government. People have been marrying before there was ever the government of Tennessee or even the United States of America.
Which, no matter what side of the line you fall on the LGBT rights, and we can all agree that that's true.
That's true. Historically, that's true.
Yeah.
They've always been married. And so we have Supreme Court cases that say, well, the right to marry, he actually says, is not conferred by the government. It's part of the common law. Men and women can marry unless the government prohibited them from doing it. And who would do that, right? So the Supreme Court said, so states created registration laws so that we'd know who was married and to provide evidence of the marriage. Those are the Supreme Court's words. We want to know, well, did you really marry or not? Well, here's how we can know. File a piece of paper, and if you've signed it, then that must mean Gary really thinks he's married, right?
It's a key word.
Yeah.
Evidence.
Yeah, it's evidence, which is what the courts used to say about the common law. My decision is evidence of the law, but don't think it is the law, because I might be wrong.
It's evidence of something that has already happened.
Yes.
Between these two
that is
people.
already true.
Yeah.
Yeah. And now I'm just trying to figure out how to apply this. So that's what they said the marriage laws were. And over time, as we began
When was that? What year was that?
That was 1877. Okay. So we still held on to this notion that there are some things that exist outside the government. But as this concept of law began to evolve through this evolutionary thinking out of Harvard and everywhere else, we began to think, no, government actually created marriage. That's what they did. But now here's the beautiful part of this. Okay, Oliver Wendell Holmes, and okay, United States Supreme Court, you said in Erie Railroad versus Tompkins that there is no transcendent law, there is no transcendent common law that applies to state and federal courts. The only common law that exists is the common law of Tennessee for Tennessee. And the common law of Kentucky can be whatever the common law of Kentucky thinks it is. And they can be quite different. And who are we to say, because the authority and only authority is the state when it comes to what the state's common law is. And so, well, in Tennessee, here's what we think common law marriage is. It's a man and a woman. We put that in the Constitution. It's the historical institution and legal contract solemnizing the relationship between one man and woman. And that's the only recognized marital contract. That's our common law. So butt out, Supreme Court. If you don't like our understanding of common law, there's nothing you can do about it, because you said it was actually unconstitutional to tell Tennessee what its common law was.
It's good.
So leave us alone.
We hadn't talked about this part.
No, but this is good. It's out there. Well, I've talked about it in other places and other times, but today on this podcast, people need to understand. So when we say the Supreme Court did not address in Obergefell common law marriage, it just said, look, we know we have cases over here like Meister v. Moore from 1877, but we're now talking about positive, statutory, enacted law marriages. So that's why my law professors say, well, the Supreme Court didn't say anything about common law marriages. We don't know what they think about common law marriages. But what I'm going to say to them is, and you don't have an opinion on common law marriage in Tennessee because you said there isn't any transcendent concept of marriage that applies in every state that even the federal government should apply to. So there we go. Leave us alone. We decided common law marriage in Tennessee is a man and a woman. And you said it was unconstitutional for you to impose, as a federal court, common law on the state of Tennessee.
It's good.
It's commandeering the courts of the state of Tennessee. And in fact, that's what he says. We, in this opinion, I don't have it copied all out here, but he said,
so they've created between Obergefell and the 1938 decision.
They've created a great opening for
two rulings that are in direct conflict with each other.
Yeah, in a sense. But see, in a way,
how can they coexist?
Here's the way to do it. They said that the right to marry is something we created out of our head, not deduced from any principle that pre-exists or history or tradition. That's why there was such a debate about history and tradition, is that Roberts and all these dissenters are saying we have no history or tradition of same-sex marriage. And they said, well, we have a history and tradition of marriage. Yeah, but the history and tradition is this way. You just changed the whole history and tradition. And they said, well, things evolve. And so now we're just going to take advantage of what the Supreme Court said and said, well, okay, you said that common law is a real thing, but it's just not real for federal courts. The only common law that exists is the common law of Tennessee or Kentucky or Michigan or wherever it is. The only state that doesn't have it is Louisiana. Sorry, y'all are all stuck. Go Tigers. And we're going to say, so here's how we define common law marriage. And when the Supreme Court says you can't define it that way, I'll say, well, you said it was unconstitutional to tell me what my common law was. So what is it? Are you going to now reverse precedent that's 82 years old?
Yeah, when it comes to abortion and Roe v. Wade, with that
yeah.
What was it in the?
Yeah, we can't reverse precedent that's 40 years old.
Yeah. Well, it was a 92 decision. They were all concerned about overturning because we've already made abortion available.
Yeah, for 27 years, or whatever it is. Yeah. We can't reverse precedent that's that old. So here's where we are now. The question is whether our state legislature has the courage and belief enough about marriage to say, okay, you created out of thin air a right to marry out of positive law. You took the word liberty, and you've changed the common law understanding of liberty, which was the ability to move around and locomotion, that, you couldn't be held captive against, blah, blah, blah. And you turned it into a liberty to just go do whatever you want to do. Well, that's a positive law declaration of it, but it's not law. That's what you think the word liberty means. But in Tennessee, here's the common law understanding, and we're just not going to have that positive law understanding of marriage anymore. We're not going to have that. So there.
We'll see how that goes.
We'll see how it goes.
That was good.
Okay.
That was good. Well, it gives us a little history on how we find ourselves in the situation that we're in. And we continue to make the point that we made last week, which was this idea that, oh gosh, the Supreme Court has ruled, that's it. That's got to go away in our thinking, because guess what? Those 9 folks sometimes get it wrong.
Yeah, they get it wrong. Actually,
quite often. What did we say? It was like 250 times
they reverse themselves.
Yeah.
That's right. Yeah.
So, in any case, well, as always, we'd love to hear your comments. You can send us an email at info@factn.org. It's info@factn.org. And excited to talk with you next time.
If you enjoyed this episode, don't forget to subscribe. And if you want to help spread the word, please give us a 5-star review and tell your friends to subscribe too. We're available on Apple Podcasts, Spotify, and wherever you listen to podcasts. God, Law, and Liberty is a podcast of the Family Action Council of Tennessee. We are a 100% supporter-funded nonprofit advocating for family, life, marriage, and religious liberty. For more information, please visit us at www.facttennessee.org. That's FACTennessee.org. And please follow us on Facebook, Twitter, and Instagram @FactTennessee.